Hey, police court. Again, my name is Stephen French of the Vinall Law Group on behalf of the appellant, Michael Flynn. With me is one of our associates, Jared Roberts, also of the same firm. This is a case brought below by the General Michael Flynn, a retired general in the United States Army, as well as a former director of defense intelligence and a former national security advisor, against the appellee Rick Wilson, who is a founder of the Lincoln Project and a media political commentator. I think most well known for authoring the book Everything Trump Touches Dies. The underlying suit involves comments that General Flynn alleges to be defamatory. The first is the allegation or statement by Mr. Wilson that General Flynn is a Putin employee, referring to Vladimir Putin, the head of the Russia. And then the second comment that General Flynn is Q of the QAnon, and I can never pronounce that word, so excuse me.
Mr. French?
Yes, ma'am.
How is the comment that General Flynn is a Putin employee really qualitatively different from Wilson's prior comments to the effect that General Flynn is in bed with the Russians? Isn't it just hyperbole?
Hyperbole may be one way to take it, Judge, and I understand that. And, you know, in this day and age, especially with the internet, these types of comments are thrown around all the time. But when you're talking about an individual like General Flynn, who has spent his entire career and has built a reputation as being kind of this ultra patriot, and you say that he is a Putin employee, well, an employee is a different word than just saying, oh, he's a fellow traveler in certain instances on certain issues. But to say he's an employee, in other words, he's being paid, he's an advocate for Putin. In other words, that's a very different story because it connotes traitor or treachery against his own government. That's why it's different. It's not just hyperbole, and it was a statement of fact. That's where this case arises, and that, frankly, goes beyond the pale. And I understand some people say, well, today's society, you know, it's the internet. What do we care? No, that's very important. You can't just go out there and say, this man who has built a career of 30 plus years in defending this country is a traitor to that country. There is going to be somebody held responsible for that type of comment.
Well, the article that was attached to that comment, not even an article, but it was a letter, an open letter, I guess, that General Flynn had written expressing some support for Putin and for Russia. And so, doesn't that give context? It wasn't an expose on how much he's, getting paid. I mean, it had nothing to do with money. It didn't refer to any sort of quid pro quo or anything like that. It was just a very favorable letter by General Flynn to the Russians. So wouldn't the average reader, the reasonable reader, say the comment that he is a Putin employee coupled with that letter, in that universe, I know I'm not articulating it very well, but it's how you distinguish between opinion and fact. When this is what I'm relying on to make this statement. And so it can be reasonably ascertained that by that statement, what all I'm saying is he's a Putin apologist. He's a Putin supporter, he's a Russian supporter, he favors the Russians.
And if he said apologist or supporter or giving some kind of cover to Putin, that's one thing. But to say he is a Putin employee is a very different thing. And I think we can recognize that word has a certain meaning. Now, I'm not going to tell you what's in General Flynn's mind when he makes those comments about the strategy of Russia during that period, but I think one could read it as General Flynn saying, here's a strategy that was taken by the Russians. And that makes sense for the Russians to do that. I don't think General Flynn will tell you here, then or now, that he was giving cover or doing anything to advocate that what Russia did was proper or correct, just that those were the circumstances that Russia availed itself of at that time. And I think it was more of an article from General Flynn criticizing the circumstances being put in place for Putin and the Russians to do what they did. And General Flynn is saying, of course they did. Look at the mess you created to allow them to do that. Which is a very different thing than saying, well, General Flynn is providing cover and support for the Russians. So I think that's where we have a disconnect on that interpretation. But again, going back to saying, well, General Flynn is not just criticizing the US government's policies that allowed Putin to do this, it could be taken to say, well, you know, General Flynn's providing this cover for Putin and the Russians. That's a very different thing than saying Putin, or saying that General Flynn is a Putin employee. Putin employee, if I get hired by somebody to go mow their lawn, they pay me to go mow their lawn. I'm doing that work for them. If General Flynn is a Putin employee, he's getting paid or some kind of compensation to come out with these comments or to do that or to advocate for Russia. That is not what he was doing at all.
The record establishes he did get compensation from a Russian entity.
In 2015, he gave a speech, all right,
He
to,
got compensation from a Russian entity.
yes,
And it's a Russian entity affiliated with the government.
I believe most every Russian agency is affiliated with the government, yes.
So would it have made a difference had Wilson said he's an agent for Putin? Or is that equally harmful or equally damaging?
It would be less severe if he had used that term.
How about if they use the term he's a shill for the Russian government or for Putin?
Again, I think it would be less severe.
So,
I'm not,
I agree with you, there are different gradations of terminology, but in the context of what's before us and what was before the trial court, would people using any of those terms be able to understand he's doing things that are benefiting Russia, he's gotten some money from Russia, he's sat next to Putin at an event and so forth? Wouldn't that entitle people to understand, reasonably understand, it's a relationship that is descriptive as opposed to legally binding? You know, he's not a legal employee of Russia, maybe not even a legal agent of Russia or a shill for Russia, but sort of that hyperbole analysis.
I think that a lot of that can go into that. If the term all the way back to the 1970s, the useful idiots, you know, was the term that people would say, well, they weren't engaged or employed by these communist countries or so forth, but they're useful idiots of the other. Now, if that was a tack that was taken and said, well, General Flynn's analysis of what's going on here benefits Russia, and we think that that's bad for America, what General Flynn is saying in his analysis of the situation, understood. And you may even say, and that makes him a shill or whatever you want to say. But that is a very different thing than say he's an employee of the man who is one of the most dangerous opponents of this
It
country.
would have been okay to say, based on all this, he looks like he's employed by Russia?
That's very close to just pure opinion, isn't it?
Well,
That's not what we have
is
here.
that though different from looking at all these circumstances? He's an employee of Russia or an employee of Putin, he's employed by Putin.
And if we look at just the circumstances that were brought up by the defendant below in response to this complaint, the only thing he ties it back to is this 2015 speech where he was paid to give a speech, all right? It's akin to, let's say, I'm a member of the bar and I go and I give a speech to a group of developers and contractors, you know, and it's paid and hosted for by this developer group or whatever else. 10 years later, I'm on the bench. You know, I've ascended, you know, I've got the robe, and that developer who hosted that conference, you know, has a suit in front of me. And the opposing side says, well, you've got a conflict. You're in the pockets of that developer. Well, that's what we're dealing with here. Just because somebody goes and gives a
You may
speech.
not have read a lot of our motions to recuse.
Oh, no. And I understand that.
If that's the first one, you're off the case.
Yeah, you know, and I understand, and that's, you know, a difference between going on the bench. Obviously, you have the recusal, and the other side can move to recuse you because of that. But if somebody were to say you need to recuse yourself because there's an appearance of impropriety, that's one thing. But if the opposing counsel went out and said that judge is in the pockets of this developer, not that there may be an appearance of impropriety, but you're in the pockets of that developer, that's a very different thing. Okay, and that's exactly what Wilson did here by saying he is a Putin employee. Is a Putin employee in 2022, was that 7-8 years after the fact that he'd given one speech, not connected to Putin, although it's all Russia, we all understand that. But it is 7-8 years down the road, a one-time instance. And this is where the problem is with, and you know, from reading the briefs, some of the issues about the burden shifting and everything else. We never get to that in this case because we never get the opportunity to do the discovery, take the deposition of Mr. Wilson. Now, was he just, so angry at General Flynn and the people who associate with General Flynn that he just says, I'm going to call him a Putin employee? And only after he gets sued does he now come back and say, oh, wait a minute, now I remember 8 years ago, look, I found out he gave a speech to Russia. Well, was that in his mind at the time he said he was a Putin employee? We don't know. And that's one of the difficulties in being a plaintiff in these cases. We never know unless a defendant in a defamation case says, especially against a public figure, hey, I really hate the guy. I said this because I have actual malice. Well, you don't know that without building the circumstantial evidence, which General Flynn in this case was never given an opportunity to do.
But you didn't know.
Never had an opportunity. The motion to dismiss was the first thing filed by by Mr. Wilson.
But it was a motion to dismiss and for summary judgment, and
Yes.
you waived the summary judgment timing.
And I was not involved. I can't answer that directly, Judge. I'm
The,
sorry.
the lawyer below, it was clearly a motion for summary judgment. There was never a request for a continuance. There was never a request to take, for discovery. And even after the order came out, where the court said, I'm resolving this on summary judgment, there was never a motion for rehearing.
And Judge, also, when we talk about what was provided in support of this motion for summary judgment, the very support that Mr. Wilson presented was also the information and facts that would have been relied upon and was relied upon by General Flynn below. And that is, this was a one-off speech. A jury could have said, hey, it's just a one-off speech. It doesn't give him any relationship to Vladimir Putin. There was a 7-year lapse. That is the uncontested facts of everything that Mr. Wilson put into the record and was supported by General Flynn. An argument by General Flynn is that these facts are disputed, not just in what they're saying they mean, but what the General Flynn is saying that they mean. A juror could look at those same facts and say, you know what, Mr. Wilson's right. It seems like we think General Flynn has some kind of connection to Putin. Maybe he is an employee, an agent, a shill, whatever you want to call it. Or a jury could have just taken the same exact facts and said, wait a minute, a one-off speech 7 years before, and he's calling him an employee of Putin. So there are facts there that a court should have said, wait a minute, there's a dispute here. There is an opportunity for a jury, a trier of fact, to go through this evidence and say, do we believe Mr. Wilson, and it's true that General Flynn was an employee or shill or agent, whatever you want to call him, of Putin, or do we believe General Flynn and that he didn't have a connection, that it was a false and malicious lie about him and calling him a traitor in the United States? I didn't mean to shut you down.
No, that's what you're doing fine.
Well, don't give me that much confidence. So that really goes into a lot of the underlying suit and addresses even a lot of what the order that we're up here seeking to have reversed. And I think the order, you can't read this order without seeing that the Gundel case, and I apologize, I'm going to say Grundle over and over because I have a childhood friend who's still a good friend, is Grundy, so I still call it Grundle. I've said it a million times, I apologize. But so the Gundel case clearly informed, if not led, the court to its decision and what it saw as the burden shifting issue here. You can't read this opinion without it. In fact, the court, even in its order, says, I'm in the second DCA geographically. I'm bound by what Gundel is telling me to do, so I'm doing this burden shifting. Of course, we've raised in our papers that the 3rd, 4th, and 5th districts have certified conflict with that ruling, understanding that some of that ruling, also the Gundel case, frankly, concerned more about this court's scope and jurisdiction to review writs of certiorari on, again, another word that I butcher, on motions to dismiss that are denied. Understanding that is most of what the Gundel case gets into. But you look to the Lamb case, which I think really is more apposite to what we're dealing with here. The Gundel case had the component of defamation, but it was tied into what rights these homeowners or members of this group had and what the restrictions were under the various documents that they entered into with these property rights. And so defamation is part of it, but it's also tied into what rights they have contractually. The Lamb case is a straight defamation case, just like this one is. And in that case, in the Lamb case, the court said, you know, the Gundel court relied upon this case from Maine and its burden shifting provision, which is expressed in the Maine statute. Florida doesn't have that.
Because the court granted both summary judgment and the motion to dismiss, do we even need to reach that issue?
I think it's important because you can't understand the order itself. Like I said, it really controls where the court is going. And I think, to be fair, the trial court overlooked a lot of the issues and arguments that were raised because it was so focused on this burden shifting issue without looking at the other arguments that General Flynn raised below.
To the extent we're here on reviewing a summary judgment order, we have to know what review of the complete record. So
Yes.
Before
I'm
you
not
finish
sure.
your answer, let me tell you what's Cat 15, so we'll be invading the corpus, so you may want to be short or long as you decide.
So I'll leave my question at that. Basically, it doesn't really matter. Do we need to reach that issue?
I don't wear the robe. Whether you should or shouldn't is a difficult question for me
That's
to
the
answer.
nicest way to give a little deference. I appreciate that.
No, it truly is, and it's a discussion I've had with others and myself. Is this the case that needs to address that issue? We obviously believe it should, that the court should address that issue because it has created a situation where courts, like the one here, get so focused on that issue, and then the difficulty is for judges going down that road and avoiding what seems to be the typical and historical way that these types of motions were dealt with. And again, the raising of disputed facts. We believe they were already in the record. And the court seems to have made this factual findings, which we point out in the briefs, things that we believe that the jury should have had the ability to do, but the court made those decisions on those disputed facts. Thank you.
Good afternoon. I'm Leonard Collins on behalf of the appellee Rick Wilson. First, I think there are a couple of mischaracterizations of the record below that I think we need to analyze. There's more than just a speech that General Flynn gave in Russia in 2015 that he was paid for. The record reflects, number one, that General Flynn was appointed as National Security Advisor. We have in the record an indictment with effectively an acceptance of responsibility on General Flynn's part for lying to the FBI concerning Russia and its investigation into Russia. We also have in this record a New York Times article where General Flynn discusses the fact that he didn't fully or completely brief the Vice President of the United States concerning an issue involving Russia. We obviously have the speech at RT, but RT isn't just a television network from Russia. We've got in the record documentation that shows that RT is much more than that in terms of government findings, that Russia is involved in spreading information. I'm sorry, that RT is involved in spreading information really on behalf of the Russian government.
Mr. Collins, if we accept your first argument that this was nothing but opinion and hyperbole, do we even need to get into these other areas that you're talking about right now, or do they only come in if we are trying to ascertain the substantial fact of the statement and the actual malice in making the statement?
So, Your Honor, I want to be clear in terms of what my argument is, because I don't know that I agree with the court in terms of how it's posited. Our argument is that the trial court was correct in its finding that that Mr. Wilson believed in the statements that he made, and therefore General Flynn could not prove falsity, that effectively that he acted with malice.
So your argument below, your primary argument, as I recall, what was first off the bat, this is opinion. This is nothing but rhetorical hyperbole.
but the court did not make that finding. And so I want to be clear, we're here to support the court's order.
Okay, well then let me ask you, because I've got your motion to dismiss in front of me.
Okay?
Can you show me where in this motion you argue substantial fact?
I don't argue substantial fact. What I argue is, first of all, I do argue substantial fact, but I also, we heavily and strongly argue the fact that Mr. Wilson believed and relied upon the articles that we attached, and therefore could not establish falsity. So for sure.
Yeah,
And-
it's all over it, but I asked you a very specific question, because I want a very specific answer. Where did you?
I cited, it's at the very beginning of our argument in the motion for summary judgment. And I can pull it. I know we cited it in
When you
our,
say argument, you're saying before the trial court or in the pleadings?
in the pleading, only in the pleading. So it's in the hard copy, and I quoted in my answer brief the specific portion that we believe covers that particular issue.
Okay, because what I'm reading here, falsity is the sine qua non for recovery in a defamation action, but the record evidence establishes that the statements are opinions that by their nature cannot be proven as true or false on political issues and are protected under the First Amendment. So,
Well, it keeps going.
well, I know it keeps going,
But
but
it-
that's what I'm asking you, because you know your motion certainly, I mean, better than I do, so where exactly are you raising falsity and arguing falsity? Because even though they have the burden of falsity, the trial court can't grant summary judgment
But
based
the
on an
trial,
argument not raised.
but Your Honor, that's not what happened. The trial court granted summary judgment on 2 issues, not 1. And with all due respect to appellant, their initial brief misstates what the court did.
The court granted summary judgment on the first 2 prongs
Correct.
of
And-
defamation,
and-
falsity and actual
belief.
malice.
And belief.
Well, falsity, well,
So
belief goes into actual malice, correct?
that's correct.
Okay.
And it's Mr. Wilson's belief. And so Mr. Wilson's belief is well established in that record.
Okay,
And
so
you-
are you abandoning then your opinion argument?
For appeal, for the purposes of appeal, we're not arguing, we're supporting the court's order. So we're not arguing an opinion at this stage because the trial court didn't find that. So we're here supporting the order that the court issued. And the court's order specifically goes through our evidence, which is compelling and has been the evidence that's in this record establishes on the Russia statement a number of really compelling issues with regard to why Mr. Wilson said what he said. General Flynn was indicted. General Flynn admitted under oath to being an agent of a foreign government. General Flynn,
Of Turkey.
well, but of Turkey, and also of issuing an article on behalf of the Turkish government when he was the National Security Advisor elect. While he was coming into office, he issued an article and didn't tell readers that he was in fact an agent of a foreign government. That gives Mr. Wilson, under these circumstances where you're talking about core free speech, the right to say what he said, which all he did was contextualize General Flynn's statement, which General Flynn had every right to make that statement. But once he did, put it on Twitter for others to see, others can comment on it. And that's all this is. If calling someone an employee of someone else who, without all of the record material that we have in this record, which the court used in order to find that Mr. Wilson didn't have knowledge of probable falsity, without it, under Sullivan, it's still okay. It's still a public figure who's making a statement, in a political statement, that necessarily is going to get a response. And the response here is tame, it is mild, compared to everything else that you would see on Twitter. That it is not. The word Putin employee, and it doesn't say he is a Putin employee. All it says is Putin employee Mike Flynn. That's it. It contextualizes who Flynn is, which readers would know based on all of the material that's in the record. That's not, that If you can't say that, then General Flynn has free speech and others reading it do not. That can't be and that is not the law. And let me just say, I think it's important. There's a case, Don King Productions versus Walt Disney. Both sides cite to it. That court found that on a motion for summary judgment in a public figure defamation case, which this is one, the burden is on plaintiff to present record evidence sufficient to satisfy the court that a genuine issue of material fact exists, which would allow a jury to find clear and convincing evidence of the existence of actual malice on the part of the defendant. It's not here. There's nothing like that in this record. There's nothing in this record. There's nothing for a jury to do in this case. Nothing. Because you can't establish actual malice. And with the standards that exist in Sullivan and its progeny, the bar for a plaintiff like General Flynn is extraordinarily high, and it is.
Let's move on to the QAnon statement, because that hasn't been addressed yet.
Oh, sure. So the record material for the QAnon statement includes multiple. So there's an article from the New York Times and an article from the Daily Mail. Both suggest that adherents to QAnon and detractors of QAnon speculate that General Flynn is QAnon.
So again, you're not arguing an opinion here. You're arguing that there is a basis in fact.
I'm arguing that there is. I am arguing the court's order. So what I am doing is I'm supporting the order that the court issued.
Okay.
And so certainly, I think you can make a very valid argument that it is an opinion. But I'm not here to do that today. Today I'm here to support the court's order and ask you to uphold it. And I think that even though a good argument can be made about opinion, a really good argument could be made about fact. Saying he first of all,
Are we limited by the trial court's legal conclusions?
you're considering this de novo, so you're not.
Okay.
But our position on this is that the court got it right. And so with regard to the he is Q, first of all, Mr. Wilson didn't even make that statement. Someone else did. All Mr. Wilson did was retweet the photo of himself.
Was a retweet like a republication of a defamatory statement?
Well, it's not a defamatory statement from our
Statement
perspective.
sitting for, are they alike? It's a retweet like a republication.
It's a republication. I mean, I think the question is who's ultimately responsible for that.
Because everybody says fewer characters, this, that, as distinguished from having a newspaper where you can write out your complete statement. The idea for these forms of communication appears to be brevity or how fast your thumbs can move or not. And if I got it wrong, then you know what everybody in the court knows. I don't do tech.
There you go. But Your Honor, so he retweeted this statement. Statement is he is Q. We put in the record, there are documentaries that PBS ran with regard to General Flynn's involvement with QAnon. There are multiple articles that talk about his involvement with QAnon. We even went and put General Flynn's own website into the record. General Flynn sells merchandise with his name on it and the slogan of QAnon, and we cited, there's a case out of the DC circuit where a circuit court, federal circuit court judge found that where we go one, we go all is a marker of that movement. And General Flynn sells merchandise with that slogan. So he is closely associated with it. What he is in it, I don't even think that statement itself says that. It doesn't.
Is that statement meant to be, is that statement ambiguous? Because it says he is Q, if Q is short for QAnon, does that mean he's a member of the organization? Does that mean he's the president of the organization? Or is that a problem in the analysis that we have to do in rendering what this is?
Well, I think that if it's not clear, and it's not, and I think that there are all kinds of ways you can interpret that. I said during the circuit case that could be Q for the character in the James Bond movie. I mean, it doesn't say what it is. And in order for it to be defamation,
Contextualize it, that's a stretch.
I think that's fair. But
Exploding vehicles or rocket launchers or...
But it really doesn't say what that is, and you really have to take some leaps to figure that out. And that's not in the record. Again, not actionable. again, there's a basis for it. And again, it's political speech. This is the type of back and forth. Sullivan protects it. You've got a public figure plaintiff who didn't put anything in the record. You've got no record on their side. The court mentioned this issue with regard to discovery or our motion for summary judgment. In the record are emails from me to counsel saying, if you need more time, we'll give it to you. And they said, no, we're ready to go. It's just not there. The initial brief has a number of issues that somehow come back later, like Mr. Wilson's affidavit, which is a core piece of evidence not raised in the initial brief. There is, at the end of the day, there are a couple of issues before I run out of time.
You might have 13, before you go to your other issues, let me raise one for you that I'm having a partial concern. I really apologize for my voice. As I look at the second amended complaint, the motion that was filed was for summary judgment or to dismiss. And I'm having a real difficulty as a matter of law concluding that the second amended complaint complies with the Florida rules of pleading. Did anybody ask the judge to rule on the pleading issue first, or did everybody try by consent to go to the summary judgment? Because the Florida rules say you have to set forth a short statement of the ultimate fact. So if Mr. Wilson committed defamation, that would be a count. If the other gentleman committed defamation, that would be a separate count. If they were acted in concert, that would be another count. And we only have 2 counts reincorporating 100-something paragraphs. I'm concerned about, did everybody elect to go on the summary judgment and not ask the trial court to rule on the pleading issue first? Because theoretically, that might have fleshed out some issues if they replet it.
So I would note this. I think that's fair. Obviously, in our motion, we pointed out that it was a shotgun pleading, and so I understand the argument the court is making. I think the issue, though, is that this is the second amended complaint, that they did have an amendment, that we did raise this issue in our motion to dismiss, motion for summary judgment to the first amended complaint. And at this point, this is what they chose to do. And so
this was the strategy of they voluntarily elected to go forward in the summary judgment aspect.
that is absolutely our understanding.
That's what we believe the record shows us.
That is correct. And the record shows that specifically with emails from me to counsel that I put into the record after the fact, after the hearing, and then the court ruled upon it, where I said, okay, we're here on a motion for summary judgment. The rule requires 40 days. Opposing counsel said, well, we're ready to go earlier. And I said, are you sure? I mean, there are multiple emails in that chain. And the answer was, yeah, we're going to go forward. And with that, we agreed to go forward. But with regard to, there's another issue that I think is extremely serious, which is the court can't let go of this case without considering who these people are. You've got a person who has a history. He's on the front cover of the New York Times. He is a former national security advisor to the President of the United States. He is one of the most prominent figures you will ever see in any anti-SLAPP suit in the state. If you look at anti-SLAPP suits and the figures and who they are, he is a substantial public figure. Mr. Wilson is a writer, and he's very well known also. The notion that this lawsuit was brought because Mr. Wilson called him a Putin employee or said he is Q is silly. It's not why this was brought. This was brought because Mr. Wilson says things that General Flynn doesn't like. And that's all over this record. It's all over the complaint. There are attacks in this complaint about Mr. Wilson changing his position overnight, about Mr. Wilson supporting candidates that are opposed to Donald Trump, and on and on. In the complaint, there's a demand for $50 million for saying Putin employee and he is Q. That's absurd. This has the hallmarks of what the legislature had in mind when it passed the anti-SLAPP law. It is plainly that has no merit and was brought to inhibit the First Amendment rights of Mr. Wilson. And in addition, we've got Mr. Wilson's book that discusses General Flynn in a pejorative light. And we have Mr. Wilson's organization, the Lincoln Project, that ran ads against General Flynn. So you've got a clash of two different personalities that are fighting in the political space. They can do that. That's okay. That if you're going to have a political disagreement, you can have it. But to have it in the courts, to use the courts, to punish someone by forcing them to hire lawyers and go through this process when there's no merit to it, that's wrong. And the court found that here. And there's good basis for it, and we're going to ask you to uphold it. So with the remaining time I have, I want to quickly, do I have remaining time?
2 minutes.
All right. Judicial notice. I think the record is very clear in terms of what the court took judicial notice of. I think the initial brief perhaps was confused, but it seems to miss the fact that Mr. Wilson filed an affidavit and attached all those materials to it. And so one of the reasons why the court found truth is because the court there was no counter evidence. So you have Mr. Wilson's statement, you have the underlying record, which is compelling from various trustworthy news sources, and then you've got nothing on the other side at all. And with nothing on the other side, the court had no choice. There was nothing else the court could do under that circumstance in a motion for summary judgment. I bring it all back to the Anderson case. The Anderson case, which is one of the cases cited by the Florida Supreme Court in terms of summary judgment, when a party doesn't bring forth counter evidence on summary judgment and the record supports summary judgment should be answered. And summary judgment should be granted. We are...
Well, there's no question your colleague relies on an outdated standard for summary judgment in Florida. So I don't think that's in question.
And under Anderson, this was the court couldn't have. There was no other evidence in this record. There was nothing else the court could have done under the circumstances. And so, based on that, respectfully, I would ask that the court uphold the trial court's order and ultimately remand the case under Florida's anti-SLAPP law in order to allow for attorney's fees and costs. The appellee. Thank you so much.
Thank you, counsel.
Sorry, just to clarify, when I said your colleague, I meant Mr. French. Your colleague on the other side.
Thank you.
Thank you, Judge.
I will anticipate the first question is how much time do I have left, right? The answer is
Okay. All right. We may not be colleagues, but it's been very collegial. And I want to apologize to the court and to counsel. On the third day of a head cold, my Sudafed decided to run out just now.
You're in good shape with me, no problem.
I'll stay over here. Going back to the Q issue, because we didn't really address it when I was up here before. This is not a secret what Mr. Wilson is saying about identifying and retweeting and publishing that General Flynn was Q. Q is not some guy who invents gadgets for MI5. Q, in this case, everybody knows, is a mastermind that is a traitor to the country. And so to say, well, the New York Times and other people are speculating and saying, well, geez, maybe General Flynn is involved. He sells materials. And so it's okay for me to come out and say, General Flynn is Q, the traitor to this country. That's a very different thing. And so I don't think that should just be glossed over.
Is there somewhere in our record, or the trial court's record, that would have the occasion, that would show us that Q is a traitor? I mean, that particular context?
I don't have it offhand.
From a person who knows the inside information, is buried deep within the deep state or something like that, that I often hear audience talk about. Because I'm not certain that I've heard the traitor. That's what prompted the question. Is it in our record? Do you believe it is?
I don't
We'll
recall
check.
specifically.
I can check this.
But Judge,
I hope you do off the
I was
top of your head.
responding to the comments that this Q, whatever it is, but that is the debate, and it's been ongoing for years. Who is Q? And it's not it's somebody who might be involved. It's a member. It's somebody that everybody is saying, who is this mastermind, so to speak? Not just some other person who might be involved or might give support to them. Okay, so to say somebody is Q is very different than just saying he supports or sells merchandise at QAnon, however you say it. On the issue about these, and further on that, court correctly points out that the motion was brought that these were opinions, not statements of facts, because as they said in their motion, you can't determine whether or not these statements are true or false anyhow, so how could they be statements of fact? Therefore, they're opinions. And the tag on to that was, well, we've attached a bunch of articles that people are speculating and saying, well, you know, what is Flynn doing? You know, who are his allegiances to? What is going on? Well, that's all the type of stuff you usually see and usually get in the press. And, you know, the response is, well, no, I'm not involved in that, and I'm going to go and use my free speech to counter your free speech. But that's not what happened here. These were statements, direct statements of fact. He's a Putin employee. He is Q. That's very different than we've got some other things out here. We think he's supporting these people because he may agree with them politically, ideologically, but nobody in these other articles that are referred to are saying, by the way, he is an employee of Putin and he is Q. So that is where the difference is. That's the jump that was made by Mr. Wilson, and that's the defamation that has been sued upon. Nobody's shutting down free speech. I know this is an argument they've raised, and it does, if we pointed out, it seems to be the argument that if a plaintiff in a defamation case says, I have damages and I want to come after you for those damages, the defendant is saying he's chilling my speech. Look at this. You know, if I say anything, they're going to come and take my money. Well, that puts a catch-22 on any plaintiff in any defamation case because allegations of damages are required to state that claim. So what are you to do? Well, defamed a person, they're going to come after for damages. That's the way it is. But the argument that that is proof of General Flynn's purpose and primary motive to bring the suit is incorrect. It's inapposite. It can't be that argument. That cannot support that leg of their
That alone would not, but I think you would agree, a trial court has to look at the full context of what's before.
Yes.
So we know people can sometimes ask for damages that are unrealistic. Sometimes they ask for too little and file in county court. Ultimately, that's just one factor that is considered.
Yes.
So I wouldn't put too much time into that argument. I don't think that's getting you anywhere.
And thank you, Judge. And I'm just responding to an argument that's in their brief about that. The fact that it's this chilling effect. It is supporting. It's a primary reason why the suit was brought was to chill Mr. Wilson. Well, no, there are damages because of a specific defamation that's been alleged. But the argument that we've read in the briefs, and I don't think it came up too much in counsel's comments before the court today, but that somehow is the chilling effect that supports the part of the anti-SLAPP law. And then that should not be the case. Otherwise, no defamation case can ever be brought for damages.
Your time has expired, but since it was based on a member of the court's questioning, I want to give you 30 seconds more to sum up.
Well, I often find, Judge, it's best for me to say, does the panel have any questions for me before I go off onto something that nobody cares about?
I don't see. Everything has been well argued and well briefed. I think we're pretty attuned to the issues, but as I said, you had 30 seconds to sum.
I'm going to take that as my cue and thank you, the court, very much for your time.
Thank you. Thank you all very much. Have a good day today and stay safe on your travels.